Good morning, ladies and gentlemen. Thank you for being here today. Earlier this morning, the New Mexico Department of Justice filed a petition for prohibition and superintendent control, naming as the responsive party a local judge in the 3rd Judicial District. This action was taken after that district court judge cut short the probationary period Patrick Howell, an individual who pled guilty to criminal sexual contact with a minor, and pursuant to New Mexico law, was required to remain on supervised probation for a period of not less than 5 years. The New Mexico Department of Justice has taken this action, not only because we believe the judge acted incooperative and in violation of the law, but more importantly, because of the way that the process unfolded. Under New Mexico law, specifically Article 2, Section 24, victims of crime in this state are entitled to certain specific rights that are enumerated and are supposed to be guaranteed by officers of the court. Those rights include the right to be treated with fairness and respect for the victim's dignity and privacy throughout the criminal justice process, the right to notification of court proceedings, the right to attend all public court proceedings, the right to make a statement to the court at sentencing and at any post-sentencing hearings for the accused. Based on our review of the available record, it does not appear to us that the district court complied with the constitutional protections that are set forth and guaranteed under law. One of the things that I think is most concerning from my perspective is that I don't believe this to be an isolated incident for the state of New Mexico. In my conversations with victim advocates, in conversations with prosecutors, in conversations with victims, in virtually every corner of this state, there has been a pattern of disregard for victims' rights, of disregarding and failing to protect on an equal basis the rights that these individuals are entitled to. And I want to take a moment to just reflect on how much courage it takes to do this, how much strength it takes to stick with the criminal justice process, especially one that doesn't seem to have your interests in mind or to place your rights on equal footing with criminal defendants. That has to change in the state of New Mexico. Victims' rights are civil rights, and the New Mexico Department of Justice intends to vindicate those rights and to protect them at every available term. To that end, I have been in touch with not only district attorney Byers, but will be reaching out to district attorneys across the state, asking them for additional evidence and occasions where any member of the judiciary has failed to properly safeguard victims' rights. And I want the people of this state to know the action that we have taken today is just the first step. In addition, I think it's time for us to have a broader conversation in the legislature about what it means to have rights articulated under our Constitution and yet have no remedy for those rights. Simply put, most of the time, when a member of the government does something that violates someone's rights, there's an opportunity, there's an avenue, there's an ability to challenge that. What we're asking for in this petition is simply for the Supreme Court to take control and order that certain procedures be followed in the district court before any modification of this individual's sentence is allowed to occur. But I think we need to be thinking more expansively and more broadly about how victims are protected and safeguarded. It's time for us as citizens, it's time for us as elected leaders to stand up and be accountable and not allow victims of crime to be treated as second-class citizens. With that, I will turn it over to District Attorney Byers to give an update on the procedural steps that he has taken, that his office has taken in response to this latest action in the district court. And I want to start at the outset by thanking him for cooperating with our office, for working closely with our office to figure out the best way forward to make sure that the victim's rights in this case are protected. Please turn on.
Thank you, Attorney General Torrez. Good morning, ladies and gentlemen. As Attorney General Torrez noted,
Our office is taking additional steps in conjunction with those by the Department of Justice to seek vindication for the rights of the victims in this case. Those steps are as follows. We filed this morning a motion for the court to reinstate the probation of the defendant Patrick Howard in this case. The reason for that is because under the statutes, a person becomes a sex offender when they enter a guilty plea, and he entered a guilty plea in this case, and that requires a mandatory period of supervised probation of no less than 5 years. In this matter, the defense filed a motion to terminate the probation early. That motion was set by the court on March 19th. It was heard on March 21st. And at that hearing, the court terminated his probation early. The reason I give you the dates is because it is significant that also under the statutes, New Mexico's crime victims, as noted by the Attorney General under the New Mexico Constitution, have a right to be present at any hearing that the defendant has a right to be present at. In this particular case, the statutes also provide that no less than 7 working days, not calendar days, 7 working days shall be provided for the court to inform the district attorney's office so that he may inform the victims in a timely manner. In this situation, my office received 2 days of prior notice, and that was 2 calendar days. And so clearly the amount of time was severely shortened, and that did not provide our office sufficient time to notify the victims. Additionally, there's another statute which requires that the court inquire of the state at the hearing whether or not the victims have been notified. That statutory obligation has not been violated as well. That is put in the statutes by the legislature as a safeguard to ensure the rights of the victims. That was not done during this hearing. And so that is why we have filed our motion with the court to request the court to reinstate the defendant's probation and also give the victims an opportunity to be heard as according to their constitutional rights. And so we're working in conjunction with the Attorney General's office, and I'm exceptionally thankful and proud of the Attorney General's office, Department of Justice, for stepping forward to vindicate the rights of victims statewide. Thanks.
Next, I'd like to invite 2 attorneys who were representing the victims in this case, Shannon Kennedy and Mon McGraw, who have dedicated themselves throughout their career to protecting victims and their rights. I believe they have a statement that one of the victims would like to share, and after that, we'll open it up to questions.
Good morning. I, along with Mon McGraw, have the honor of representing a young woman who was Patrick Howard's favorite. The young woman who took him before a federal jury to uphold her civil rights, to expose Patrick Howard, the way he sexually groomed her and those in her school, her friends, the manner in which he touched her for his sexual gratification. He put his needs before the rights, the dignity, and the bodily integrity of his students. She went to trial and testified so that that would never happen again. Yesterday, she completed her first year of vet school in Washington State. Otherwise, she'd be here. And she asked that I read these words in her absence. District Attorney Byers, thank you for apologizing and for taking accountability for the situation at hand. We have not had a whole lot of that in the past 7.5 years. I'd like to keep it simple because honestly, I'm still at a loss for words in all of this. The justice system has failed us one too many times, and it is incredibly disappointing that after fighting for justice and finally being heard, we were immediately undermined. His probation was reduced by 2 years within 2 weeks of the federal civil rights verdict of $44 million. I really hope that the order to terminate Patrick Howard's felony probation is thoroughly reconsidered because I, along with the other girls, fought so hard so this could never happen again by the hand of him. And I fear history may repeat itself if it's not reconsidered. As far as the Victims' Rights Act goes, I do think it needs to be taken much more seriously, and everything that can be done should be done so that this does not happen again. Thank you for your time, and please do right for us and the community.
Good morning. My name is Molly McGraw. I'm one of the attorneys along with Shannon Kennedy that have represented a number of the victims. And in the federal jury trial that took place from March 4th to March 11th, we were counsel for that plaintiff was one of the victims and was noted to be by Mr. Howard, his favorite. I took the under oath examination of Mr. Howard during that federal jury trial here in Los Cruces. During that testimony, he admitted to violating the constitutional rights of his 15 and 16-year-old student. He also admitted to having a beating stick that he used to whack students in class and to throwing markers at their heads to get them to pay attention. He ruled by fear and intimidation, and he sexually groomed and abused multiple female students. The evidence is clear. What has been also very clear over the last 7.5 years is that Patrick Howard's constitutional rights have been complied with and observed. That those constitutional rights of his victims have been disregarded at multiple times. We are here to give voice on behalf of those victims and ask that their constitutional rights be considered on equal footing with those of any criminal defendant. Thank you.
And with that, we'll open it up for questions.
Yes, my name is John Cardinelli. I'm with KOAT. My question today is, why wasn't anything said at Patrick Howard's hearing regarding the possible violation of the Victims' Rights Act?
I reviewed the hearing about the change of plea or the termination of his probation, and at all times relevant, the probation and parole officer was asked whether or not the defendant had complied with the terms and conditions of his probation, and the probation officer gave the court his idea that he deferred to the discretion of the court. As far as the challenge of the maintaining the rights of the criminal defense, of the victims at that hearing, that was not brought forward. And as I was not there, I can't give you a solid answer. Should it have been raised? Yes, it should have been. Whether or not it would have been considered by the court, I don't really have a firm feeling about that. But what I can tell you is my review of the record of the hearing indicates that no, that was not done.
Sam Emerson with KBIA. Just Attorney General Torrez, has your office spoken with Judge Driggs?
No, and it wouldn't be appropriate at this point for us, as he has now been named as a responsible party in the petition that we filed with the Supreme Court. I will note that in general, it actually is the Office of the Attorney General and specifically the Department of Justice that is called upon by the judiciary to represent judges, and whenever there's a petition like this that's being brought. However, there are mechanisms in place for our agency to assist in and retaining independent counsel to represent them in this case.
Attorney General Torrez, sir, can you just explain, just for our audience, what this petition of writ is and what the process of that will be?
So, under our law, the Supreme Court in the state of New Mexico has what's called superintending control. It means it has ultimate control over the procedural conduct of any cases that are occurring in any inferior court across the state. Because this current resolution does not lend itself for the typical kind of appeal, we have to file what's called an extraordinary writ, which means it's an uncommon
pleading an uncommon action that our office is taking, but effectively, we are asking the Supreme Court to recognize that there were multiple violations of the law that were committed by a misapplication of that law by the judge itself. Not only the substance in the reduction of the sentence itself, it's our position, as the advisors mentioned, that this defendant should be subject to a mandatory 5-year term of supervised probation. That was not complied with. More importantly, however, is that the procedure itself was defective and should be nullified because it did not comply with the constitutional rights of victims under the United States Constitution.
Any other questions in the room? I'm going to send to just
Justin Garcia, Los Cruces schools, and you mentioned one of the biggest concerns that we've had issued with mine victims' rights. Can you speak a little bit more about that?
Well, I can speak from my own experience. When I, nearly 20 years ago now, was a frontline prosecutor in Valencia County. Not long after the two constitutional statutory provisions had been enacted, I was prosecuting an individual who was accused of committing a violent sexual assault of a fellow high school student. And the debate that was had at that time was about whether or not modifications should be made for his pretrial release because he happened to be an accomplished high school athlete. And there was an argument made that modifications of his pretrial supervision should be adjusted so he could participate in a sporting event. I not only argued that it was inappropriate for that kind of argument to be made to the court, I also notified the court that the victim has an independent right to have their own advocate. And so Ms. Raw, Ms. Kennedy, they actually, under our law, have an independent right to go in, file a notice of appearance on behalf of the victim, and make an independent argument. The judge in that case ruled against this and said, no, the victims don't have that right, don't have the ability to do that. And so in response to that, I actually filed an extraordinary writ as a frontline ADA in Valencia County a long time ago. That went up to the Supreme Court, and ultimately the court ruled in our favor and enshrined into law and directed all future proceedings that victims of crime had the ability to go and hire their own attorney and enter an appearance. That sort of thing has occurred over and over and over again. And I'll let some of the advocates here talk about the specifics, but we have repeatedly had situations. For example, when I talked about the right to be treated with fairness and respect for victims' dignity and privacy, you would be astonished. You would be shocked if you were allowed to sit in a pretrial witness interview of a sexual assault victim, a child abuse victim. I want you to imagine what it would look like if a 10 or 11 or 12-year-old was sitting across the table from a defense investigator or a defense attorney, and they were harassed and intimidated, called liars, their characters impugned, and it's done in a way that frankly causes substantial harm and trauma. In response to that, when I was district attorney in Bernalillo County, we actually advanced legislation that would have prohibited that kind of question. I don't know that most of you are aware of this. In virtually no other state in this country is that permitted. You are not permitted to badger and harass sexual assault victims and child abuse victims about the trauma that they have endured. If someone is attacked or assaulted on tribal land and they end up in a U.S. attorney's office, they have no ability to do that. You don't get to threaten and harass defendants or victims about their experience. And it's done in a way that sets a more even balance between victims of crime and criminal defendants. My perspective is this. We're not asking that victims of crime be treated better in terms of the respect for their constitutional rights. The buyers and I have both taken an oath to uphold the law and do justice, and that means making sure that criminal defendants have due process and the rights of certain. All we're asking for is so that victims of crime be treated equally, that their rights be served, that their rights be protected. And, we see it in a lot of different contexts. We have judges ordering the disclosure of medical records, of psychiatric reports. Imagine that. I want each of you to imagine what it would be like to have a minor child summon the courage to disclose to you that someone harmed them, or touched them, or God forbid raped them. And you go and try to seek medical care for them. And then someone goes into court and says, we have a right to look at those medical records. The New Mexico Constitution says the right is to be treated with fairness and respect for the victim's dignity and privacy. And yet somehow, when we go into court, those rights get ignored. And that has to stop. And that's what we're here to talk about. And that's what we're going to do.
We're going to do 2 more questions in the room, John and Jason, and then we have a few on the Zoom.
Perfect. John Cardinelli from KOAT again. Have there been any other cases involving Judge Driggers in which he did not notify victims in a timely fashion?
I can't speak to that, but that's the advice listening.
Thank you. I don't have any particular case right off the top of my head. You can go back and do an analysis of that. What I can say is that I echo Attorney General Torres's concern and demand for the equality of rights, because our local police chief had noted recently that oftentimes the criminals' rights are given greater standing than those of the victims. I have practiced in 4 different jurisdictions in this state for the last 26 years. I prosecuted Dominic Akers in 2004 for the murder of Marissa Matthew Zeifler in the Sunshine Theater, which brought forth Marissa's Law, which then required sex offenders to notify their employers that they are a sex offender, notify institutions of higher education that they are a sex offender. We have been in this fight concerning victims' rights for well over 2 decades now. And I agree, it is high time that the rights of victims be accorded to them in a meaningful way in our courts of law.
So, the most recent news, is there something that can be done to strengthen or change the statutes regarding categorization of sex offender and victim storage and state?
Well, we set forth in the petition that's filed today a comprehensive argument as to why, under current law, sex offenders like Mr. Howard should be subject to the mandatory term of supervision. I will certainly work with key legislators to look at that language and with fresh eyes to see if there needs to be further clarification on that point. But the second part that I think deserves as much attention as that particular question is something that I have had a conversation with these very experienced advocates. This is one of the few areas of law where there are rights rather than remedies. And our laws are not designed in such a way that we create a baseline expectation for judicial officers and others to abide by the law, and yet if they fail to abide by the law, that our options are similar. In other instances, when you have rights, you have their remedies. And I think one of the most critical questions moving forward is whether or not it makes sense to continue to have victims be disadvantaged by having rights that exist on paper, but somehow never seen them materialize in reality.
So we're going to go to the Zoom. We've got a couple questions. So I'm asking these folks to unmute themselves. So Brittany.
Can you guys hear me?
Yes.
Yes.
Okay, it's Brittany Costello with KOE4. Couple quick questions. First, how likely is it to reinstate his probation? How often does that happen? And then the other question that I'd like you to hit on is when we talked to probation and parole as we were working on this story, they made it sound like this kind of probation reduction isn't exactly out of the norm, even with relation to the sex charge. And so they have made it sound like, 2 years, whatever, he served his time, he did it, whatever. Is there, specifically as it relates to these sex crimes, Can you talk about whether or not this may not be the only case? If they are making it sound like this is kind of happening, is it possible that other sexual crime victims are having their offenders get their probation slashed?
Brittany, I would say that it's not only possible, it's, in my judgment, it's probably very likely. That this may have occurred in other jurisdictions, and that's precisely why we're reaching out to district attorneys to get more specific information about cases that we need to re-examine and look at. I would also note that this sort of cavalier attitude that's been expressed by probation and parole is deeply concerning to me. One of the things that was noteworthy from what little I gathered from the record that was explored is not only did probation and parole fail to sort of push back on this idea with the court that the sentence could be reduced, somehow an argument was made that by simply doing what he was ordered to do, that he somehow earned the right to have his sentence shortened. That's not how our system is supposed to work. He was ordered to serve and comply with conditions, and he should not get the benefit of a shortened period of supervision by simply doing what the court expects him to do. And so those are, frankly, cultural issues that I think should properly be examined by the people in charge of probation and parole.
Thank you, Brittany. We're going to go to Chris McKee on Care City.
Hey there, just making sure you can hear me okay.
Yes.
Yes.
Okay, thank you. I know that the judge in this particular case, Judge Douglas Riggers, has also faced criticism from prosecutors over, I would say, the last 6 years. I can point to at least 3 cases, 2 involving the prior AG's administration. He was criticized for the sentencing of 6 judicial district attorney Francesca Esteves in 2018 for giving conditional discharge in a plea deal. In 2022, the Supreme Court removed him from the Baby Bobby case, saying he abused his authority as a judge when banned prosecutors from using exhibits like 911 calls and photographs as punishment for missed trial deadlines. And then in 2022, there was also that controversial dismissal of a second-degree murder charge against a former Los Angeles police officer accused of killing a man in a chokehold. And now there are these accusations, and it is very clearly all the exact same judge here over the last 6 years. And now I understand, well, this has been posited as an issue to look at across the courts. What this also says to me is that we've got 4 different cases where there's controversy with the same judge. And I wonder if perhaps Jamie Byers or A.G. Torrez, if you would address any criticism or concern that you have over the behavioral choices of this particular judge.
I do not disagree with the litany of situations that you've described and the outcome. Each of those sent outrage throughout our community. I cannot begin to tell you how frustrating that is as a prosecutor who is leading other prosecutors. Then you have to resort to, as for example, in the Baby Bobby case, getting an extraordinary writ in order to see that justice is done to the victims. We had to do that. We used the tools that were available to us under the law to secure justice. As far as any further comment, I will just, my rules of professional responsibility require that I just sort of stop there. But I think that the record that you articulated speaks volumes.
We're going to do one last question, and then Brittany had a follow-up, and then we're going to wrap.
Yeah, I just wanted to circle back to that original question that I had, which was, how likely is it to reinstate Howard's probation?
So, Brittany, what has happened today is our office has filed with the New Mexico Supreme Court. The Byers has filed a motion with the district court itself. We don't yet know how either one of those 2 pleadings will be treated by the court because of the procedural nature of the extraordinary writ that we filed. I would imagine we would get a relatively quick decision
with respect to whether or not we even state proceedings, and that's one of the things that we articulated in the writ. So, as DA Byers and I would, I think, agree, predicting the outcome of anything in either the appellate court or the district court, something of this nature, is virtually impossible. My firm belief is that the law on the sentencing of sex offenders is clear, and equally clear are the rights that victims of crime are entitled to, and just on its face. Reading nothing other than the record and comparing the record to what is outlined in the Victims of Crime Act and the constitutional provisions, it's quite clear that they fall well short of the legal standard. And so my hope is that we would get a positive outcome from the Supreme Court, but we certainly aren't going to prejudge that. Any other questions? Thank you very much. We appreciate your attention.
Thank you.